we're here to talk about mental health, okay? By the way, if you want to have glorious answers of how to resolve the issues, good luck with that. It's a challenge. Where are you folks from geographically? Somebody shout out an area. Santa Cruz, okay. Sacramento.
Yeah,
Sacramento. Any Southern Californians?
Yes.
You're from Southern California?
Yes.
Okay, you like our water? No. You'll get that. So you're from Ventura. Okay. By the way, for folks in Ventura, you have one of the best NAMIs in the country, NAMI Ventura here. You know, for the subject of mental health, we'll be talking a little bit about NAMI, so that's great. Any other areas? Are we mostly professionals? I have a sneaky suspicion there could be a consumer or two here. Anybody from Disability Rights California? Okay. There we go. I hope you like most of what I say. I can guarantee you won't like it all. That's okay. That's not our job. And we're here for diversity. I am going to squeeze 2 hours of material into an hour and 10 minutes. I am going to go through this as fast as I can. You do have handouts here. As always, I have added to the handouts. So one thing is, I think there is a notebook in the back. If you give me your email address, I will email you a copy of this PowerPoint as it was finished. What you have is mostly what's in the PowerPoint. I would suggest that you not be too focused on the handout. First off, it's an itty-bitty type, and most of you guys are a whole lot younger than I am. I know I couldn't possibly read that even with, glasses. I am going to read some law. It's not going to be that bad here, but I'm going to read law because it's kind of fascinating. When you read the law, you find all sorts of stuff. Also, in the back, there's a DVD on doing estate planning for people with mental health issues. There is also a DVD, and last year my program was on alternatives to limited conservatorships. By the way, if you give me your email address, I'll send you a link to last year's. I knew this room was too small. I'm happy to send you. If you missed last year and I thought it was a pretty good program, it's on YouTube. Okay, so if you want to go to the Dale Law Firm website. Here, it'll direct you to a link to last year's program, which is on alternatives to conservatorships. There is a DVD on limited conservatorships. That's not exactly our topic today, but it's kind of related here, and all sorts of other things. And, like any attorney, of course, I'm full of myself and would love to spend an hour and 10 minutes talking about myself, but I don't think that's what Andy wants me to do, so I want to come back next year. By the way, how many of you is this the first time you've been to this conference? Okay. I know most of you don't have any idea who I am, but I'm going to introduce myself in a minute. I go to conferences across the country. This is one of my favorite conferences, okay? I mean, and by the way, it's a very challenging thing. If you're not offended by something, you're not alive. I mean, I just got to say, but, this is one of those things where, the disability community, that we can be very proud of this here, really, this is where we excel, okay? And I enjoy this, and I go every year that I'm invited. So, and I will tell you, I travel across the country. Here, I'm kind of a disability wonk here, and I travel across the country teaching attorneys about the disability community, and I get to meet with the leaders of NAMI and the leaders of the ARC. Here, we'll go into a little bit about who those folks are, and it always reminds me that for developmental disabilities, we are in the best place possible. Sadly, for mental health, not so much, okay? And I'm going to go through this. And part of this, the theme is going to be, celebrating all of this, but for our mental health brethren, deinstitutionalization has not been as successful as for folks with developmental disabilities. My personal feeling is, as long as there is a major segment of our disability community that is underserved, or not even underserved, unserved, we are not free. Our job is not done, okay? And so, you know, this is one of those things where there is not a conference like this for folks with mental health issues. There are conferences, but nothing like this. They don't have regional centers. They don't have transition fairs. You know, I will tell you, I went to a transition fair here recently, and I had a couple come to me and ask me, I've got a 30-year-old daughter with severe schizophrenia. She's in severe danger here. We don't know what to do. Of all those 60 or 70 tables out there with residential programs and vocational programs and all that, they said, Mr. Dale, what are those tables are for me? I looked over that sea and I said, sadly, very, very little. Okay? And that's something that as advocates should really disturb us. Okay? We should celebrate what happened with developmental disabilities, not so much with mental health. I will just tell you, that's my view. And by the way, in going through this, in no way am I suggesting we should go back to state hospitals. I'll tell you, I came out of state hospitals, you know, when I talk about this, I am not suggesting let's go backwards to state hospitals. I'm suggesting let's keep a promise that was made in 1993 or 1963 and was lost many years ago. So let's go through this. As we all know, in a supportive life of all places, we know about telling our own stories. I'm going to start by telling my own story here. A little bit about my background. I know the lighting is really bad in here, but see this picture right here? There's 4 people here. By the way, that's me a couple of years ago. Actually, I know exactly how long ago it was. It was 40 years ago because that guy is 40 years old. And the reason I'm putting this up is I come from a family of state hospital workers. In my day, I actually grew up part of my life on the grounds of Agnew State Hospital as a family member. It was a real common thing here. My father, no, there he is. My father was a psychiatric nurse for about 45 years. My grandfather was what would be considered a psychiatric nurse in those days for over 40 years. I was a psychiatric nurse for 17 years. My son will not be a psychiatric nurse. Basically, that's the end of the story here in those days. And I'm going to go through. I believe that you can't really understand what the problems are unless you look at history. So I'm going to do a little history for you. Come from 3 generations of psych nurse workers, grew up on the ground. Some of the fondest memories I have are being at Agnew State Hospital, you know, because I used to go to the units and do all those things because I didn't know any better. Okay, I mean, that's where I grew up here. I'm not going to suggest it was the greatest place in the world. I will tell you it wasn't a total hellhole. I'm sure there were bad things going on, and we're going to go through some of the bad things. But I actually became an attorney because I worked in a state hospital and I saw some abuse, and my interest in becoming an attorney was to shut down what I considered abusive institutions. What I learned for mental health is be careful what you wish for because you may get it, and that's part of what I'm going to go through. So as we go through this, you know, this is my background. This is how I got involved in this. I became I did some work, and you guys have a handout about my history because, once again, like all attorneys, I am completely full of myself, and I love that article, so I want to share it with you here. But it goes through a little bit of the history, and, you know, we all bring something to the table. You know, we're all stakeholders here, and what I want to bring to the table is today is the failure of our mental health system and how that affects persons with developmental disabilities. My personal observations for persons with developmental disabilities, we have the best system in the country, and deinstitutionalization has been a great success. Anybody want to open up the developmental centers again? No. For our brethren with mental disorders, it has been less so. In fact, I'll go even further. In many ways, it's been an unmitigated disaster, okay? So for persons with dual diagnoses, it can be really challenging, okay? And I'll share with you a story. And I'm going to share with you a lot of stories, and most of them are actually true, okay? But this one is true. I was one of the admitting nurses. As we talk about the commitment process and how this works, I was one of the committing nurses in San Francisco here before I switched over to become an attorney. And I got wrote up because on a Friday afternoon, there was a severely developmentally disabled person who was brought to my admitting room. There was nowhere for him to go here, and I admitted him, and I got wrote up because it took 3 months to get this character out of the hospital because there were no services. Now today they don't allow us to do that, but once again, a lot of times people that are admitted to psych facilities, it's an inappropriate place for them to be. And maybe if we get time, we can talk about some examples, because I'm going to probably be pointing out more problems than solutions, but this is how things get changed. Key. I'm going to go back to this in a minute, but just in case I don't get through the PowerPoint, NAMI, California. NAMI, California. Burn it in your brain. NAMI, California. Okay? If you are interested in mental health issues, that's where you go. Okay? And you can get their newsletters. Joining them is $35. Now, by the way, the ARC is cheaper. They're $25, but they're $35 to join this. This is the leading disability organization dealing with mental health issues nationally, statewide, and if you have one in your community, absolutely must be familiar with them. Absolutely must be familiar with their programs. One of their best programs is a program called Family to Family. Don't have time to get into it. Anybody familiar with NAMI? Okay. Disagree? NAMI, California. Okay, remember that. Okay, what we're going to cover. We're going to talk about the history of the institutionalization for persons with mental illness. Much different than the history for developmental disabilities. Much, much different. Okay, a comparison between the Lanterman Act, the system that is the most successful in the country, and the Lanterman-Petrus Short Act, which in my view has been a disaster. Okay, and we need to pick up where we started and improve these systems, not just for folks that are dual diagnosed, but for everyone with psychiatric disability. A review of the LPS Act for involuntary commitments. It's not just to go through conservatorships and that kind of thing, but I'll tell you one thing. There's something fascinating when you actually open up the law and read it. And in fact, for those of you who do a lot of work with folks with developmental disabilities, they have a program called Keep the Lanterman Promise. Absolutely profound for people with developmental disabilities. You know what they do? They read the law, top to bottom. There are all sorts of juicy little things in there. I'm going to go through, going through the law. I've highlighted what I think we should focus on. It just really is kind of fascinating reading the law, even if you're not an attorney, okay? And we're going to talk about the specific challenges that persons with developmental disabilities and their families encounter when they're seeking services, and we jump from one program to the other. Let's begin with the story. Where did this all start? Okay, first psychiatric institution is in 1773. We are embedded with doing that. By the way, they didn't put this together because somebody said, let's create some sort of nightmare hellhole. They did it in most cases because they really were trying to put together systems. That's what they did back there. It started with the best of intentions, although sometimes good intentions are the road to hell, and that's probably what happened here. Indiana, very key, not only in mental health law, but in developmental disability law, and is really key to why sometimes our laws are the way they are. In 1907, Indiana was the first of as many as 30 states that started compulsory sterilization law. They called it Eugenics Law. Not just the Nazis did this. We actually, this is terrible, Hitler picked it up from us, okay? So we were leaders, okay? Probably with the best of intentions, but probably not a good idea. It allowed a total of almost 20,000 folks that were labeled mentally ill that we know of that were sterilized. California was a leader in that movement here, and that actually helped to heat up the deinstitutionalization movement, because along the line there were a number of persons with disabilities, both developmental disabilities and mental health, and advocates, and civil rights, those pesky civil rights attorneys who started thinking, well, maybe we shouldn't be sterilizing a bunch of people just because they're in a particular class. We can all go along with that. And that is one reason, which is not today's topic, where it is very, very difficult today to sterilize a person legally with a disability. But that's not today's subject. In 1936, and this is something that affected my life, my father worked in a post-lobotomy unit. We start moving into the medical model here of mental illness here. And so in 1936, they started doing what are called lobotomies. And lobotomies, if you haven't seen One Flew Over the Cuckoo's Nest, is cutting the frontal lobe, which is kind of where our personalities are here. And if you do that, if you start whacking off pieces of the brain, people's behaviors do change. Okay, little on the barbaric side. By the 1950s, especially at Agnew State Hospital, they were going 1,000,000 miles an hour. That was the center. And once again, my father worked a post-lobotomy unit. Not one of our brightest periods with mental health. It will kind of show you how far we can go given the initiative. In 1938, then we introduced electroshock treatment. I worked the last forced electroshock unit in the state of California. Here, it's very different today. There are cases where people do get electroshock, and it can be a great treatment for folks that have severe depression. But in those days, if we didn't know what to do with it, we just run a whole lot of electricity through their head and see what happens. And, you know, maybe some will get better, some won't. Those days are over. 1954, big change, okay? Big change. And here's why. In my father's and grandfather's day, almost all state hospitals were farms, okay? They didn't just lock everybody up. Almost everybody worked, okay? And in fact, to me, a state hospital was a place where it just sure had a lot of food, okay? And that changed. In 1954, they started coming up with what they call phenothiazines, which are psychiatric medications. They're derivatives of cold medications, okay? So if you ever, those of us who deal with Thorazine and that kind of thing, you know, sometimes they have really dry mouths. It's like taking a bottle of cold medication. They're all chemically the same, and that's why the side effects are much the same. And so part of this is, it was one of the first medications specifically for mental illness. One of the effects of it, and I don't know how many nurses you have out there, I have given as much as 1,000 milligrams a day to a single patient, which I can guarantee you, if I gave that to everybody in this room, about 50% of you would die. I mean, it's incredible, okay? But, you know, it's in those days, if it didn't kill you, we called it a therapeutic dose here. By the way, I'm not saying this entirely to be funny or entertaining. It's just the reality of the situation. One thing about phenothiazines, okay? There are good things about the medications. There's some bad things about the medications. Now it allows us to medicate them out of their minds. And it makes it easier to warehouse them, okay? Because when they're not medicated, believe me, as a psych nurse working on a unit here, it's not the safest place in the world for the patients. It's not the safest place in the world for the staff. It's much safer if we just medicate everybody out of their minds here. Probably not the kind of treatment we're looking for. So that's where we had a big change. In 1955, we hit the peak of over 500,000 Americans in psychiatric hospitals. Then we start heading down, and this is where we start with the best of intentions. Okay, nationally, where did this start? And you can almost pinpoint this to March of 1990 or 1963, when John F. Kennedy signed the Community Mental Health Act to provide federal funding for construction of community-based programs, basically to shut down the institutions in favor of community programs. Okay, and in a way, that's when things really started cooking. Most of you are much too young for this. I remember as a child a big focus on mental illness, stuff on the TV set, a big focus of how we're going to put these programs together. My father worked in very progressive programs to work on moving to the community, highly funded in the early days. In fact, in the early days, much better funded than developmental disabilities. As we'll see, there's the rabbit and the turtle. The turtle won, the rabbit got fried. That's a terrible, but that's pretty much what happened. Okay, 1967, here's something familiar. Well, no, not yet. We passed what's called the Lanterman-Petrus Short Act, which I'm going to go through probably in painful detail here, which makes involuntary commitment much more difficult. In my father's and grandfather's day, we didn't really pay a whole lot of attention to civil rights and that kind of thing. In fact, you could commit somebody without there being a hearing. You could sterilize them without a hearing. You could cut their pieces of their brains out without a hearing. You know, in 1967, they said, we're going to stop that. And you'll notice that Lanterman guy, he was involved in a lot of stuff. Okay, so this is the LPS Act, not the Lanterman Act. Similar, not the same. 1 year after that goes into effect here, the number of people that are mentally ill in the justice system doubles. That's key. A lot of us that are advocates in mental health, once again, the criminalization of mental illness is something that if it doesn't disturb us, it should, because that has become the treatment center. 1981, Mr. Ronald Reagan, and I'll show you something really confusing. He repeals the community mental health legislation, establishes block grants. Don't have time to get into block grants. Evil. Okay? I mean, when you get into block grants, you're usually going to run into problems. Federally mental health spending decreases by 30% almost overnight. By the way, Ronald Reagan helped to establish our regional center system in California, just to confuse the heck of us. So he is one of the founders of what we're celebrating today. For mental health, we wouldn't be celebrating Mr. Reagan here, but that's as far as I'm going on that, okay? So studies suggest that 60% of prison and jail inmates have serious mental illness, approximately 320,000 folks. In 2013, there are 100,000 psychiatric beds. We're talking across the country. That means that there are 3 times as many seriously mentally ill people in jails than in hospitals. How's that? Here, 43,000 psychiatric beds in the United States, 14%, or 14 beds per 100,000 people, the same as 1850. Okay, so we don't have a lot of beds. Let's look at our system. As we go through that, what is the Lanterman Act, other than a bunch of stuff I'm going to read you here? It is California's Civil Rights Act, and it is. Okay, I'm not saying the LPS Act is bad or evil. I'm saying the application in California is bad and evil. Okay, not the law. In fact, the law is got some really good stuff in it. Okay, so it was named for Frank Lanterman, Nicholas Petrus, and Alan Short. The intent of the LPS Act was to end involuntary lifetime commitments. You know, once again, it used to be in my dad's and granddad's day. Once you're in, you're in. You know, here, and so it was set up to end that. I think at this conference, certainly we can all be in favor of that, and establish a right to due process. By the way, due process is incredibly important when we're dealing with providing services for anybody with a disability. You know, it can get a little ugly sometimes, but it's one of those things that without paying attention to people's civil rights, we'll do things like start lopping off pieces of their brains here and running electricity through their head just for the heck of it, okay? I mean, so it leads to really bad stuff, okay? So, history, it was first, the LPS Act, because let's get into California, was signed in 1967. Within 2 years of implementation, the number of involuntary patients in state hospitals dropped from 18,831 to 12,671. That's a significant number. By 1973, there were only 7,000 remaining in the current 5 state hospitals here. California eventually closed 25,000 state hospital institution beds. Here currently we have about 6,000 and change. Most of these are either there for what's called forensic reasons. Either they're there because they're not reasoned by by reason of insanity, sexually violent predators. This is part of what Atascadero is all about, and admitted by court orders. So once again, it's not really a primary treatment area. When I worked at Napa State Hospital, I worked at Alameda County program, and these were folks straight off the street from Alameda County. They don't do that anymore. Currently we're under duress. There's 400 hospitals in California, not including state hospitals and developmental centers. We have 339 emergency departments with 14,000 psychiatric visits a year. 70 of the emergency departments have closed from 2000 to 2010. About 130 hospitals provide that inpatient psychiatric care. About 6,500 inpatient psychiatric beds serve nearly 38 million people. That's not a really good ratio here. And 25 of California's 58 counties have no psychiatric services at all, period, end of game. Okay? Here. Involuntary treatment law. So here's what California did as we walk through it. And I'm going to do this ideally not just to run through the law and show you that I actually do know how to read, but to go through where is it relevant to this group. By the way, not all attorneys can read, but I can read. Okay, it's a good thing. And here's the process as we go through this. Okay, because as we go through the process, keeping in mind, this is our Civil Rights Act for people with psychiatric disabilities. Similar, not the same for folks with developmental disabilities. Key in this process, when we're talking about getting somebody care here involuntarily, okay, is that we have what's called the 5150 process. We're going to go through just briefly. The 5250 process, there's a theme here. We'll get into conservatorships and 5350, and throughout that I'm going to share with you some things in the law that as advocates and consumers and providers hopefully will help teach you something worthwhile. Let's start with the 5150. In order, I get this all the time because of my background of working with folks with psychiatric disabilities. I am forever bound to that community. And I get calls every week from parents who say, Steve, my daughter, my son has a psychiatric disability. First, I try to find out, is there any way we can call it a developmental disability? Because if we can, we got more goodies. In most cases, we can't, okay? And we go, my son, my daughter is doing these dangerous things. I need to do something. There's got to be some help. How can I make my son or daughter do something, that clearly is in their best interest, and they're harming themselves? It's breaking my heart. All that. What can I do? Not much. Okay, and that's the thing you have to look at. I mean, and that's where NAMI really helps when you run into those families, because a lot of that is within NAMI. You have a lot of, like through the parent-to-parent program, here in the family-to-family program, where people can really learn from each other, not only what services, what meager services they have in their community, but how to be part of a community. By the way, disability flourishes with community, okay? And it dies, a sad and painful death when there's isolation and no community. We are thriving, they are dying. We need to help them, okay? With that. So they say, here's the thing that comes up. You cannot, you can't. We'll go through who can. There will be no forcing of treatment against somebody's will unless you can show that they are a danger to themselves, a danger to others, and gravely disabled. Now you would think, well, that can't be that hard. Yes, it is. And it really depends on the county here. And in my home county of Contra Costa County, by the way, and I'm recording this, and the folks who run the services in Contra Costa County, the leaders should be ashamed of themselves here. In Contra Costa County, we have amongst the least amount of services in the state. Absolutely. Do not have a psychiatric break in Contra Costa County, and I'm not kidding. better to drive to Alameda, a little bit better. Monterey, even better still. Ventura, you know, I mean, there's not a great place to have, but, you know, it's stupid that where you live makes so much difference. And I will share something with you. Remember we were having some budget problems a while back? Anybody remember that? I remember that. And they were talking, there was this proposal going around. Why do we have a regional center system when every county has a social service program? Why don't we just shut down that big monster problematic system, and why don't we just shift it to the counties? And I'm screaming, don't do it. That's what they did with mental health. You can almost see when they shifted the financial obligation from the state to the counties, that's where it all imploded, okay? So the problem with it is, depending on your county, I come from a really bad county, and I don't even know where a good county, I know where better counties are, don't have a psychiatric ranking in Contra Costa County. I'm here to tell you. So danger to others means really severely, and usually when you cross that line, you're going to end up in the jail system. That's what's going to happen. More progressive counties like San Francisco County have what are called jail courts. We don't have, well, we're Contra Costa County, we don't have jail courts. I mean, if you learn your system, jail courts can be a good thing because it's a diversion out of the jails into system. Gravely disabled, as we're going to see a little bit, isn't just, you know, that's the inability to provide food and shelter. There you go, that's got to be an easy one to hit. I got across from my office, you know, there is a bridge, and there are probably some of my clients' kids are right under that bridge. Right now you go, well, most of those folks obviously are gravely disabled. No, they're not, because they're not dying of malnutrition, okay? I clean up the empty boxes that they did the dumpster diving in. That's not what we're talking about here. We're talking inability to feed yourself to the point that you could die. That is a very high standard. We're going to go through how that works. Danger to self. You go, well, in a lot of cases, people become very suicidal, and that should be easy. No, it's not, okay? And what is happening, a lot of it, I think, having to do with money, and it blows people away. And like many things with disability, until you experience, you go, this can't be so. It's so. Is oftentimes most counties will get you to the point where you are stable, and then they will discharge you in a moment. I had a client who made 5 serious, not little cut, serious suicidal attempts in a row within a period of a year and a half. Number 6 was the end of the game here, and he was discharged every time as soon as he was medically stabilized. And you'd go, this can't happen. I will show you one of the reasons why it happened here, and it has to do with the law, and it has to do with lack of accountability here, and I will show you this. And, you know, once again, this is something in the law that should be changed. So for that, the purpose of the 72-hour hold is for observation. So they can be detained for up to 72 hours. Okay. And by the way, in most cases, 72 hours means 72 hours. In my day, when I was a young nurse, we had all sorts of ways to play games with that, like, you know, we're heading into a 3-day weekend, so maybe that really means 6 days. Well, as it turns out, no, 3 means 3. And those pesky civil rights people, what are you going to do? Which, by the way, is a good thing. Okay, so after that, if it's determined they need further treatment, and as we'll see, because I'm running through this, and they're unable to volunteer for treatment, then they can be certified for no more than 14 days for intensive treatment. By the way, if you are actively suicidal at the end of that, you can double it for 28, okay? But for 14 days. And at that point, the idea is to treat them, you know, usually get them on medications. By the way, I kind of suggested that the old days of Thorazine are evil. One of the keys is that, you know, for many folks with mental illness, is that medications oftentimes are the tool. By the way, these medications have no street value, okay? Has anybody ever offered you to have a Thorazine or a Navaine? Here, I got a Navaine here for $5, you know. It doesn't have a street value, okay? By the way, as an old hippie in Berkeley, it's really good for bringing down somebody who's on a LPS or on a LSD trip, but that's not what we're here to talk about here. So anyway, other than that, it doesn't have a lot. It's not a feel-good drug. It's like taking a bottle of cold medication. If you want to know how it feels, don't take a bottle of cold medication. Okay, actually, if we do the video, we'll put a little thing up there. Don't try this at home. Okay, so part of that is the 14 days. Let's get into, let's say you get to that end of that period and you happen to be in a responsible county. Probably not Contra Costa. Okay, so that really is taking this seriously and is really focused on care and commitment to pay for that care. Let's go the next step. Now we're going to get into the conservatorship world, so I'm going to do a little background before we get into this. What is a conservatorship overall? Okay, and there's many types of conservatorships. I'm going to go through them real quick just so that we can compare and contrast as we go through the law. Here, so there are conservatorships of the person, which are making personal decisions, and there's conservatorships of the estate for making financial and decisions about stuff. Okay, and as we go through this, for anyone who's watching this, especially watch the conservatorship of the estate as we go through these laws and conservatorship of the person, because one of the things I want to address is, what if you are one of these conservatorships, not the bottom one, the LPS? Does that mean that I have any rights at all? Now, one thing that these presentations force you to do is actually read, and I would have told you before Andy asked me to do this, to go, no, absolutely not. And as I go through there's little gems in here, and I'm going, oh my God, there are some powers. So let's go through this. The general conservatorship, oftentimes called the probate conservatorship, 9 times, maybe 95 times out of 100, is for seniors. This is what my children would like to do for or to me here, and I'm going to do everything possible not to let that happen. But that's oftentimes for seniors who become demented or cannot really control their things. There's a good reason for conservatorships when done properly and not misused. For the person, it's for making personal decisions, so usually making medical decisions and getting records. For the estate, it's for managing stuff. The next one in California is the limited conservatorship, which was last year's presentation, but that is specifically for folks with developmental disabilities. Now, as an aside, because they tend to write these laws really poorly, I think the law clearly indicates that for a person with a developmental disability, limited conservatorships are specifically for this population. Unfortunately, that's not exactly what the law says. I think that's the spirit of the law. So it is not uncommon for a person who is developmentally disabled to have a general conservatorship. I think it should be a limited. That's not today's subject. So there's a conservatorship of the person and the estate. We're going to get into that a little bit more since we're here. Most of us care about folks with developmental disabilities. I'm going to go through that so we can compare and contrast the two conservatorships. The last one, which is what I'm going to really get into, is LPS Conservatorships, which is a psychiatric conservatorship. Okay, so what is a limited conservatorship? And in 3 slides I've got a DVD back there that goes on for an hour and a half, but I only got time for 3 slides here, so let's go through it. What is it? A limited conservatorship is a judicial proceeding. All conservatorships are judicial proceedings, okay? They're done in probate courts, okay? For persons whose developmental disability substantially impairs their ability to care for themselves or their property. So you just can't say, hey, Bob is developmentally disabled. Clearly he can't make decisions for himself. Clearly he has to have a conservatorship. It's not that simple, nor should it be. It has to be not just because you're developmentally disabled, because as we all know, there are many folks there's a vast majority of folks here with developmental disabilities that are totally capable of making decisions for themselves, and there's probably people in this conference that if you tried to make decisions for them, they probably would hurt you. Okay, so so that's what it's for. The powers you can ask for, if you can demonstrate the need, is the right to select the residence. And as I go through this, because I want to compare and contrast, I want to go through something as far as the practical side. So if you ask for this right, and then we'll see how that compares with an LPS, that means you have the right to select the residence. Can you force that person to live in the residence? Somebody take a guess. No, absolutely not. Okay, so So, once again, you can say, I want my kid to live in the Red Lion Inn. At the IPP, they're going to say, that's fine by me. We're not paying for it here. Probably not even in Alta are they going to pay for the Red Lion Inn on an ongoing basis. And the other thing is, probably what your caseworker is going to say is, and I don't know how you're going to make Johnny stay there, because you can't. Okay, and that's one of the things with an LPS conservatorship that I think a lot of people realize is it may give you a power, but enforcement, I don't know. You can have access to confidential records. That makes a lot of sense. As we're going to see, since the topic is mental health, guess what records you can't get? Psychiatric records. Okay, so if you're doing, and part of this is, if you're doing a limited conservatorship to get control of the psychiatric issues of your developmentally disabled loved one, this may have some value, but this is not the end all. And I know parents sometimes are really confused when their developmentally disabled loved one is admitted into a psychiatric hospital. They lay down that conservatorship paper, and the hospital staff say, that's nice, doesn't apply here. And they're going, say what? Absolutely. Okay, the right to consent or withhold consent for marriage, there's fascinating stuff about that. Let's pass on that. Here, the right of the limited conservatee to contract. Now we'll see something very similar. This is almost like the right to undo contracts, okay? But to contract on behalf of them. The right to give or withhold medical consent. Once again, I would say for limited conservatorships, this is the single greatest issue oftentimes that we deal with. The other stuff is nice. That actually has some teeth. And because of the subject, you guys are going to know the answer. Guess where this won't help you? In the psychiatric facility, period, okay? Maybe somewhere, not in most of the counties I work with. The right to control social sexual contacts. I will tell you, this is oftentimes the big fight about asking for that right. Okay, by the way, we ask for this all the time. We get about 2/3 of the time, but guess what? The Contra Costa County Police Department is not going to stop your sexually active, developmentally disabled daughter from having sex, even if you have a piece of paper that says you can. Okay, this is I think one of the most useless powers. There's way too much time spent on this because you can't enforce it. Okay, if I could get a piece of paper stopping somebody's promiscuous daughter from having sex, I would have parents lined at my door, but I can't. Okay, so once again, we're going to get back on track again. But for those of you caseworkers and that kind of thing, this is just a bunch of stuff. Okay, rights and decisions regarding education. Okay, these are the only reason I'm going through that now is just to go through as we compare and contrast between the two conservatorships. What are restricted? You can't use it to lock them up in a psychiatric facility. In some counties, it's absolutely useless. In most counties, it's just useless. If somebody knows a county where it's, personally, I think that should indicate an indication that this is really your advocate and that kind of thing. And personally, I would like to see it beefed up because I think that when somebody is in a psychiatric facility, at least give the conservator access to records and that kind of thing. Because how can we know that the staff is doing their job if nobody's watching them? But anyway, no treatment with experimental drugs. For those of us who work with folks with autism in the spectrum, every so often people, that's going to be on the next slide, but people are experimenting all the time. Look at, these are people, they're not test rats, and no, we shouldn't be giving them treatment with experimental drugs unless we get a court order, and even then we shouldn't. This is the one. I know for autism, every so often somebody gets this bright idea. Let's just run a whole lot of electricity through their head and see what happens, and maybe that'll fix it, and we've kind of learned that that doesn't really help. So you can't give electroshock treatment without court permission, and no sterilization without special permission. This is something that's near and dear to me, and I bet if we went through it, I would probably upset somebody, but that's not our topic today. Okay, let's get back to LPS conservatorships, okay? A conservatorship is established under the LPS Acts, are part of the mental health treatment system. Okay, the primary difference between a probate conservatorship, what we saw as the general conservatorship, and the LPS conservatorships are the powers and also the ability to force them involuntarily to be either in a locked facility, or as we'll see, there are some situations where there is a little use power where you can actually use it in outpatient services. And I think a lot of the administrators somehow lost that. So, going through it, for greatly disabled, a person is not greatly disabled if they can survive safely, and the definition of safely, I think, is a little loose here, without involuntary detention. The guys under the bridge by my office, by the way, if you ever come and visit, I'll go and I'll introduce you to them. I know them by name at this point here, but they still won't, you know, they definitely, all of them need treatment, but they are able to survive. That's about it. So if the person can survive safely with the help of family, friends, and others willing to help them provide for food, clothing, and shelter, it's not appropriate to conserve them and force them to get treatment. Now here's the oddball thing, and I think this is where sometimes people are discharged, and this will go against every bone in our body for those of us that are advocates. If you volunteer and say, well, forced to do it, I will feed my son and I will hold my I will house my son and that kind of thing, then the county can go, whoopee, we can discharge him, it's not our problem anymore, even though he is just... By the way, did you notice when we went through the whole conservatorship thing, it didn't say severely psychiatrically impaired, it didn't say acting under delusions, it didn't, you know, it didn't say that, okay? There is no law in California for being mentally ill, okay? Good, bad, or indifferent, there isn't. And the person can be incredibly impaired, incredibly out of touch with reality, but it comes down to danger to yourself, danger to others, gravely disabled in the most extreme sense you could imagine, okay? Here, so once again, if somebody volunteers and says, well, I'll be there for them, then once again, the conservatorship can be cut off and the person can be discharged. I think sometimes, and you know, once again, families don't come to me because they don't care about their mentally ill loved one. They come to me because they do. And it's sad to say that, you know, in this case, if they're threatening discharge, don't volunteer to take care of your kid, even though in the end we know you're going to. Okay? So, here, I'm not saying turn our back. I'm just saying we all play the game. Got to play the game. Okay, a conservator may be appointed for a greatly disabled minor. That's one minor difference in the laws. You can't do that in normal conservatorships. Appointment of a conservator shall be subject to a list of priorities unless the officer providing the investigation recommends otherwise. As you go through the process, and I don't have time to go a great deal through the process, one of the key decision makers is the court investigator, who is an employee of the judge. Don't ever piss off, don't ever piss off the court investigator. That's the judge's employee, and they usually don't like that, okay? They're a little protective, and that is oftentimes one of the most important folks. So if that investigator, you know, once again, makes a recommendation, it's not absolutely binding, but it's about as close as you're going to get here. The court shall consider the purpose and the protection of the public as well as the treatment of the conservatee. Well, that makes a certain amount of sense here. No conservatorship of the estate shall be established under an LPS. This is important for somebody in this room, okay? Part of this is, as we'll go through, we cannot initiate an LPS conservatorship. That's not how it works. It's initiated by the county or by a designated person. But if one of the concerns is control of assets, if you do have a conservatorship of the estate and they are conserved under the LPS system, then what the law says is that conservatorship of the estate continues and the county's not going to get control of that money. Some counties are really good at managing people's financial affairs, some not so much, and I have seen some counties here who I think have done things that are more self-serving for the county than the disabled person themselves. Because, you know, one of the things we're dealing with, and there's some terrible, there are some terrible things in the law Here, the worst of it, we still have on the books that when you are discharged from a state hospital for mental health reasons, they distinguish for developmental disabilities, and you come into money, you have a lien that's payable immediately, not when you die, immediately. So we treat people, we get them ready to go in the community, and then we say, and by the way, you can never own anything. Believe me, staying in a state hospital is wonky expensive, okay? We're talking wonky expensive. And those people can never inherit. Well, it's the same thing in a case like this for mental illness. And with mental illness, people do get better. So we get them better, we get them stable, we get them on a regime and that kind of thing. It's good to keep their finances intact if we can, because they're going to need that to live. Does that make sense? Right? So that's oftentimes why, if you are the advocate, you might want to be at least the conservator of the estate, because quite frankly, I would trust you more than the counties. It's not, by the way, it's not that we, you know, I was a civil servant. Nobody goes into civil service to be rude, okay? Nobody does. I mean, it does change you. Any civil servants in the room? Anybody want to know? Admit they're a civil servant? Okay. People, that's not why you do this. People enter into it for the best of all reasons. But the thing about it is, these folks are overburdened, they don't have a lot of resources, and they tend not to manage things really well. A superior court can appoint an existing guardian or conservator of the person, or another person as conservator of the person under an LPS. This is really important. Okay, here's why. Did I mention that I have a problem with Contra Costa County? Contra Costa County will tell you you cannot be the conservator, the LPS conservator. Maybe in a minute we'll talk about whether you should or shouldn't. This says they can. Lo and behold. That's why once in a while reading the law is kind of a cool thing here. So it's one of those things that if you really wanted to be the LPS conservator, you kind of, what it says here is that you can be appointed, and despite the fact that it would be a nuisance for the county, you can be appointed. It says it right in the law here. Let me mention this as we go through this. If you have a loved one who is going through the conservatorship process, and the basic reason for the conservatorship process in most cases is to continue treatment past that 3-day hold, 14-day hold, past the 17 days. Okay, here, if you want to be the conservator, the LPS conservator, you should get in writing, sign that you made this request. Because guess what? They'll space it out. You can tell the nurse and the advocates are not going to be digging through this and all that kind of thing. And I used to, when I was worked for the public defender's office in Alameda County, I used to do the commitments here because I had experience as a nurse, and so they thought, well, maybe I know something about this here. And it isn't exactly a kangaroo court, but it kind of goes bam, 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 bam. These things happen very quickly. Here they have lots of people. So if that's what you want to do, you do have a right to ask. Why don't we take a minute and discuss, should you? Maybe you want to be that conservator and maybe you don't. One of the advantages of being the conservator is you're going to have some real solid rights, and they're going to have to listen to you, and you're going to have rights to records and that kind of thing. On the other hand, you know, if you have a bad relationship, because sadly for many folks with serious mental illness, it could be very taxing on the family. I mean, in fact, I got to tell you, the folks that really reach out to me is that this is a very difficult population to deal with. Oftentimes these very loving parents here are doing the best they can, and because of the mental illness, sometimes the person with mental illness will be less than polite, nice to them. And you know, for me, when people realize that and understand that's my child and I'm there to help them, even if they spit in my face, I'm there for them. You know, as far as I'm concerned, God bless them. You know, to me that reaches out to me here. But with that, if you have a pretty toxic relationship, maybe you don't want to ask. But can you? Absolutely, no question about it. If the county's telling you you can't, they're wrong. Okay, so the person shall have a right to a jury trial for real. Okay, and so one of the things that comes up is you can ask for a jury trial. I know, I don't know what it's like today, but I know in my day, it was kind of like, well, you can have a jury trial. And then we'd move on to the next thing. It wasn't like a big thing here. You know, they would be told, but I wouldn't say that we emphasize that a whole lot. The conservatorship investigation can make a recommendation about the conservatorship, and the recommendation shall designate the most suitable person, corporation, state, or whatever, employee. By the way, if they, you know, this is something ripe for lawsuit. If they are always recommending the county, they're not doing an assessment, they're following a policy, and it should be challenged, okay? There's this group called Disability Rights California. I think they have a table here. That's a big focus of them, and, you know, once again, they are probably the leading organization when it comes to protecting these rights. And by the way, even when I disagree with what they do, God bless them that they're there, because who's going to protect these people's civil rights? And if we don't have disagreements, well, how fun would that be? Okay, so anyway, the jury trial is to be within 10 days. We don't get to languish on these things. And by the way, you can ask, if the thing is re-upped, you can ask for a jury trial. Again, it's not a one-shot deal. Okay, so I'm going to go through some of this. Part of this is, no, I think I did that twice. Okay. You know, because we're running out of time and I want to get to some other things, part of this is, in this whole process, we can do all this petitioning. You can have all these powers. This is kind of good to go through. In the conservatorship process, there are specific things you can ask for, okay? And these have to be okayed by the court. You can ask for the right to suspend the privilege of having a driver's license. There is a tough subject to deal with, because as we know in California, having an automobile can be important. Sometimes automobiles and mental illness don't match real well. Sometimes they do. I mean, we shouldn't make assumptions about anything. Right to enter into contracts. We may have a situation where this isn't absolutely granted, but we may have something where this is a good idea, because, you know, for instance, I work with a lot of folks that have bipolar disorders, and I've got a guy named Bob, that's not his real name, who, you know, works with me, and when he's doing real well here, he does extremely well. When the evil Bob shows up, and he shows up about once a year, he does all sorts of terrible things when he goes through his manic stage. By the way, usually racking up ridiculous expenses. Unfortunately, the good Bob's got to pay the bill. And all kidding aside, those of us who work with mental health issues, well, we ever see that? Absolutely, we see that all the time here. And if that's what's going on, that is something you can ask for. Disqualification for voting privileges, the right to refuse or consent to treatment related specifically to the conservatees being gravely disabled, the right to refuse consent to routine medical treatment unrelated to recurrence, remedying or preventing the recurrence of the conservatees being gravely disabled. That sounds like a good one. And disqualification from possessing a firearm. A subject probably best not I get involved with. Okay, so anyway, why do we need, never mind. Neither conservator, whether temporary or permanent, shall be held criminally or civilly liable. I will tell you something else. If you really dig through the law, the people with the counties making this decision, everyone making decisions for this person, is not held criminally and civilly liable. Now, for the conservator, I can see that makes sense. I mean, unless you really breach your duty. Remember I told you about the person made 5 serious suicidal attempts, and on the 6th one, we went. This absolutely cannot be so. This is such a horrible breach. I can't imagine a court not suing the pants off the county here. And unfortunately, you know, suing is not the only way of doing things, but that's something that the hospitals understand. You cannot sue the county or the decision makers for making incredibly painful, terrible decisions. I think that's wrong. I think if they are not they are not meeting their obligation if somebody, for instance, is seriously suicidal and abdicating, you know, the spirit of the law. I think we should sue the pants off of them, and I think we should put them in the county square and whack them on the bottom. But that's, you know, there's something should happen, because we as a community should be responsible for that level of folks. You know, there's a debate going on, if you aren't noticing, about whether or not, you know, we as a country should pay for people with disabilities or not. That's a debate that's been going on a long time. We're very much into this debate. We are so low down the road for this community. It's just incredible. If there's a conservatorship of the estate and the thing is terminated, the conservator shall have a reasonable time to basically tie things up, which include collecting assets, because oftentimes that's important, payment of expenses, and if they're involved in a real estate sale, then they can continue to do that. By the way, there are laws that say you cannot sell the house out from underneath somebody merely because they've been hospitalized, and that's because of some really bad things happening and that kind of thing. It's very difficult to sell, and it should be. It should be difficult to sell somebody's home unless you are absolutely clear they're never going to return. That's their home, for God's sake, okay? But if it has been determined, then they can continue that work. Upon the termination of the conservatorship, which lasts a year, then you can ask for a reappointment for 1 more year. And then once again, to do that, you have to get the opinion of 2 licensed physicians or a licensed psychologist and a whole bunch of other stuff that I'm not going to read to you unless you really want me to. Okay, so common questions. Hang on. Common questions that come up, and I'm gonna switch over to something real quick. Quite frankly, this is the first time I've done this presentation, so I didn't know if I'd run out of time or have time left over. By the way, for you that do public speaking, try to end right at the end, because otherwise you're going to have people ask questions and they might ask you a question you don't know the answer to here. But let me just go through a couple things, and then I'll tell you what, in the last 8 minutes, maybe we can discuss things. So unfortunately, I don't have all the websites up. There will tend to be very poor services generally for people with psychiatric disabilities. There's been a growing understanding of the need for folks that are dual diagnosed here, and there are programs that are emerging. I know we have one in Alameda County that's been on the books for some time here, and that kind of thing. Are we anywhere near where we should be? I doubt if anybody would say yes, those of us that are in the know. There are some folks, now for instance, right here in Sacramento County, there's a group called La Familia. There is a great program in Lake County. There are pockets of programs here and there, but they're very few and far between. And I think in many ways, along with this whole trip, this whole adventure of deinstitutionalization for folks with developmental disabilities, we're recognizing that aging are issues. We're recognizing that just because you have a developmental disability doesn't mean you can't get another disability along the line, including, you know, a psychiatric disability, including bipolar disorders and that kind of thing. It doesn't exempt you. It seems like it should, but it doesn't here. And so there's this growing understanding. So we're finding pockets here and there, and I would suggest in many ways, when you have those pockets, I know that a lot of the directors are looking at sharing with each other, but we have some, but not a ton of them here. You know, once again, partnering with NAMI California here, of which, you know, once again, I think this is an incredibly important group, and that we need to do more partnering with NAMI here and kind of cut that division between the two groups, because we have one thing in common for sure, which is deinstitutionalization, okay? If you're at this conference, you can't be really for deinstitutionalization. I don't think they're going to let you in, or for institutionalization, I don't think they'll let you in. They might run you out of here. Maybe I'll do a program next year on the advantages of institutionalization and see how that goes here. This would be the wrong group to do it with, you know, here. But this is a good group to work with. Okay. Questions, comments? Anybody think I'm completely full of crap? You do. Okay. Yes, sir.
You know what it is? I stay away from Southern California, Dion says.
You stay away from Southern California?
Dances.
Dances.
Yes.
Okay.
It's because the Southern California dances are not good dances.
Oh, the dances! Okay. Well, that sounds good. That's a good thing. There we go. Yes, sir.
You list counties, what would you say Sonoma County is in regards to mental health care?
You know what? I do a fair amount of work in Sonoma County, and I can't think of any. Nothing's come to my attention. So if there is some wonderful program, I haven't seen it. In Sonoma County here, of course, you have Becoming Independent, which is probably like, or are you with Becoming Independent?
Yes,
well, I was going to go. They're kind of, almost in every county there will be one big program. In Sonoma, what is it? BI, right? Yeah, so if BI doesn't know it, it probably doesn't exist. Yes, ma'am.
Is there an argument for, because I get sent, I recommend, I've got a client who needs mental health services and the county says, oh, that's regional center, and the regional center says, oh no, mental health. Is there an
excellent question. Just because you're a regional center client and they look at all those wonderful programs here doesn't mean that your consumer, person with a developmental disability, is not able to get services. No, wrong. There's nothing in the law. Anybody from DRC? Am I missing something? Anybody from DRC where there's a thing in the law that says people with developmental disabilities need not apply? No, wrong, ignorant. I mean, you're one up as far as services with developmental disabilities overall, and they would kill for what we take for granted. But no, absolutely not. And when you hear that, this is one of those things where we need an advocacy and systems change. Yeah. Nothing to, yeah.
What organization do you say was in Sacramento?
In Sacramento, there's a group called La Familia.
Spell it.
LAFAMILIA. I think it's Spanish for family. By the way, if you look at La Familia, which I did, there are 100,000 La Familias. It's not the one in Alameda County. La Familia in Sacramento County. Anybody familiar with that program?
It's
Yeah.
La Familia Counseling Center, right? They have a number of services within.
Yeah.
But yeah, it's located here in Sacramento.
Yeah.
I've done an outreach to them.
There's not a ton of competition, so I would say they're an outstanding program
Yeah, good group.
because and I bet you they are. Even if they aren't, they're, no, but they are. And I think this is a growing understanding of the need. I know on their website they have a lot of statistical information about the incidence of mental health issues with folks with developmental disabilities, and it's very, very, very high. I got 2 minutes to kill. Yes?
Will the ACA change the landscape on treatment?
Yes, and I'll tell you what, and the question is, will the ACA change the landscape on treatment? It will, much as with autism, okay, because what we're seeing is an opening of more and more parity and a requirement that mental health treatment be provided. Now, it's not an end-all to all situations, but it is one of those things. I'll tell you quite honestly, and I've been doing this for quite some time, and I kind of learned when there's a major change to the law, I don't have to be the first one to learn it. There's smarter guys than me that'll do it. Then I learn it, then I can say I thought of all this stuff here. But I'm going to a conference next week, and I work very closely with the NAMI National folks. The NAMI National folks here, Andrew Sperling and Ron Honberg, have been hammering on this for years. And so what they're trying to do is through ACA or Obamacare here, try to make sure that we get as many mental health services as possible. It will expand services. It doesn't help us as far as we can tell, yes, as far as we can tell with long-term care services and that kind of thing. It definitely is something. I know that the folks at NAMI, California here are a little disappointed. Of course they want more. Of course they want more. Okay, and they'll advocate for more. And for our community, developmental disabilities, partnering on these issues with NAMI is one of the most effective ways to go. And we have a lot of interests in common, not just mental health. here. We have a lot of interests in common. I've got like a couple more minutes. Yes, ma'am.
What do you do when you have, like let's say I work for supported living and respite care services, and you have a parent and her son is in the program, and he has, she has a, I believe it's a limited conservatorship.
Yes.
He has some psychiatric issues, and she's frustrated with San Joaquin County mental health. She can't get access to her to his records. She tries to, show him the paper and says, "Look what powers I have," and they're like, "Sorry, we can't do anything about that." What's the solution?
Okay, and here's the question, just to repeat it, paraphrase it shorter. Common, everyday situation. Parent who is advocate for disabled child, limited conservator of the person, so for instance, if you walked into Kaiser Hospital and they're a Kaiser patient and you say, "Give me those records," they will give you everything but the psychiatric records. If you say, "I want to be intimately involved in my child's medical care, and I got this piece of paper that I spent probably way too much money on to get it," they'll give it to you, or they better. Okay, psychiatric, you're out of luck. Okay, it actually, I don't believe, maybe the DRC people disagree with me, I don't believe the law says you can't give them the psychiatric records. I know, in fact, you're not going to get them without an LPS conservatorship. Here's a problem as far as I'm concerned, okay? My reason for becoming an attorney is because the incidence of abuse, whether you are in a state hospital, developmental center, group home, San Joaquin psych facility, whatever it is, the incidence of abuse is incredibly high, okay? And part of this is, if you're isolating that consumer and that parent who has been adjudicated having the ability to have access to records is blocked, I think that person is less safe. I personally believe, I can understand maybe why they shouldn't have absolute say in psychiatric treatment. I don't understand why that block. It makes no sense, and it makes your person, your consumer you're working with, less safe. This is an area we should change, because it's, so here's my wish list, advocates. I don't think that's right. I think that whether you think conservatorships are the greatest thing or the most evil thing in the world, I think if the court went to the trouble of limiting somebody's civil rights, and that's what we're doing here, to give the right to somebody else, the right to records, I think they should have a right to those records, and I think they should have almost unfettered access to that person for their safety, okay? And that kind of thing, that needs to be changed, okay? If they shouldn't be doing this, then they shouldn't be the conservator, period, end of game. I don't think that counties and people making these decisions should be absolutely immune from being sued. Okay, I don't think we should have a situation where every time they make a decision, we're going to file a civil suit against them. That's not what I'm saying. But we have laws that block protection of these people and allow them to make incredibly life and death decisions based on money. Let's face it, based on money here. I don't believe that our county officials and our county folks that are making these decisions should be absolutely immune from prosecution. I think they should be held personally liable if they make an incredible, set a high standard. But, we have to do that because what we have is a system that rewards not giving care. My county, did I mention I have a problem with Contra Costa County? But it's not just Contra Costa County. Anybody else experiencing this? It's not just Contra Costa County. My county is more focused on pensions. And by the way, I'm a former union leader, and okay, that's important. They're more focused on county pensions than protecting the rights and the needs of people with mental health issues. I am out of time. I want to thank you. I will be here for the next 2 days. Next day. Thanks.